Hello, my name is Richard Nix. I'm here with two of my partners, Brandon Long and John Paparonis. We're here today to talk about employee benefit plans, specifically health and welfare plans, and the impact that they've had with regard to the three stimulus packages. But before we get started, I want to update you on two things that our firm, McAfee Taft, has done to try and assist our clients as they delve into the problems that have been coming about with regard to the COVID-19 crisis. The first thing we did is we implemented and are constantly updating a COVID-19 resource center. You can find that at our website, McAfeeTaft.com. But the objective of that is we have continued to do webinars like these. We attach links within the resource center. Likewise, the alerts that many of you are receiving, and quick commercial, if you're not signed up to get the alerts, that's the quickest and best way we can get that information. Everything's fluid right now, so as we get new information about the acts, new acts are adopted, or we get guidance from governmental agencies, the Department of Labor, the IRS, we are getting that to our clients and friends as fast as we can, and the best way to do that is through the alerts. But we also have other articles and other commentary within that. Understanding that your time is limited, we wanted to put this all at one resource so that you could go there, hopefully get the information you need and get back to your day-to-day activity. The second thing we did is we formed a quick response team, a COVID-19 quick response team. We did the same thing back in 2007, 2008 when Lehman Brothers crisis occurred. We found that's the best way we could serve our clients, by putting a team together that could specifically address the issues of that specific point. So if you go to our website, you can see our quick response teams. Hopefully that will be a good resource for you. But again, all of this is for you so that when you get on our site, you can maneuver around it and hopefully get the information that you need. But today we're here to talk about employee benefits. Again, health and welfare plans. A lot of information out there, three stimulus packages, Brandon and John, that are out there. A lot of information. So Brandon, quick update kind of where we are and how did these stimulus packages impact our health plans?
Well, John and I are going to cover kind of the specifics of the various provisions in the Families First Act in particular, but even the CARES Act that was published on, or the president signed on Friday, has some provisions in it. By and large, these packages don't impact health plans that much. They require coverage of coronavirus testing, certain preventive coverage, but by and large, not a lot of impact on health plans directly. And so we're really faced with the same rules that we've had all along in trying to deal with things like leaves of absence and terminations and what can we, helping employees pay premiums. Those kinds of questions are what we've been dealing with in the last few weeks.
Okay, John, what about you? What are you seeing? What are you hearing from clients?
I think Brandon's exactly right. It's presenting this, the same type of issues, and it's a matter of applying the rules that we've already have for employee benefits and trying to apply them to things that employers are going to be doing to try to address the COVID crisis.
So with that, tell me some of the things that you believe the employer as the plan sponsor are going to have to do, either to the plans or communication out to the participants with regard to their participation in the plans.
Well, a very common issue right now, Richard, relates, employers are asking, we're having to either put people on leave of absence, where you have furloughs. Can we continue to cover them under our health plan? And so one of the, just kind of, I think very specifically starting out with that question, it really depends on whether the client is fully insured or self-funded. Mm-hmm. If you're a self-funded client, a self-funded employer, this is a pretty easy question. If you have to send your employees home and there's some period of time where they're either not getting paid or they're getting paid at a reduced rate, you have a lot of flexibility to amend your plan document to provide coverage for them where they might not otherwise have coverage, assuming your stop-loss carrier approves it. And so that's really the key for a self-funded client. Look at your plan document. If you have to put people on a leave of absence or a furlough, look at your plan document, see what it provides. Usually it will say something like eligible employees are those that work on average 30 hours a week or 130 hours a month. And so usually if someone is on a leave of absence, that can trigger a loss of coverage. But if you're self-funded, you can amend your plan document with your stop-loss carrier's blessing to provide that coverage. It's a little harder, Richard, if you're fully insured, which is a lot of our smaller employer clients. A lot of employers generally that have less than 120, 150 employees are fully insured. And those insurance contracts will have a provision in them typically that define an eligible employee as someone that works less than a certain number of hours. 24 hours is very common. I mean, for example, I've seen a lot of Blue Cross documents in the last few weeks that define an eligible employee as someone that works 24 hours a week. And if someone is working less than that, theoretically, they should not be covered under the policy or the plan. So you just need to look at your insurance contract and see what it provides. You have less flexibility to amend that, but to the extent someone would lose coverage in a fully insured plan because of the provisions in the policy, you might get with your consultant or your broker and see if there's any flexibility. For example, some of these carriers, I know I heard a carrier in Tulsa is waiving the actively at work requirement or whatever the hours requirement is for eligibility. And I've heard that others are at least giving a pass through the end of April or some period of time. So get with your broker or consultant if you're a small employer.
And if you do that, obviously get it in writing.
Yeah, sure.
So that you have the
Absolutely.
coverage.
Yes. And that makes me think of one other thing, Richard. To the extent someone goes on a leave of absence or their hours drop below the hours required that you would normally have for coverage, that usually is a COBRA event, right? If a loss of hours causes a reduction in hours causes a loss in coverage, that's usually a COBRA event that entitles someone to COBRA coverage. And John, I'm interested in your perspective on this, or if you agree. But that COBRA period would normally start at the time the coverage is lost, and you might want to treat this as somehow a COBRA event and have this period of coverage that you're extending. You might want to treat that as kind of running or using up some of that COBRA period, and so you may need to amend your plan, or you may need to put in place a policy to reflect that, or something along those lines. What do you think, John?
Well, I think it does. It could cause a triggering of COBRA if the employee that goes on leave is paying a rate that's more than what they paid as an active employee, and so that would be a reduction in hours, and their coverage is they're having to pay more, and so that constitutes a triggering of COBRA. So yeah, that's something that would have to be if the employer did a continuation of coverage during the leave of absence, that would cause them to have to issue COBRA notices to those employees.
And you probably just answered this, but just to be clear, typically in the past, health plans, the document's the document. With so many changes, and no matter how you classify it, you've terminated them, you furloughed them, they're on leave of absence. Does any of that matter? And if you do make some concessions, either self-insured or fully insured, with regard to these type issues, how much of that needs to be documented? Either amending the plans to allow for this, including the coverage of the COVID-19 tests and those type things.
Well, you need to amend your plan. Certainly, you need to amend your plan.
Right.
And especially if you're self-funded, you'll need to amend your plan. But you also need to give your employees some sort of a notice of what you're doing so that they know what the rules are. And like a summary material modifications might be required, an amendment to your summary plan description, but something to reflect in your plan document that you're still complying with your plan document, and then something to give your employees so that they know kind of what the rules are. I think now, if there ever was time for you to use any of your goodwill or to make close calls and do the right thing and figure out how to paper it up later, I'm not suggesting we take unnecessary legal risk, but find a way, if you can, to adjust your document, get with your stop-loss carrier. I think they will understand. I even had one fully insured client, a small employer, who we were trying to figure out a way to get their employees to continue to have coverage while they were on a leave of absence. Mm-hmm. And the insurance carrier, when we talked to him, basically said, you can ask, it's kind of a don't ask, don't tell kind of scenario. Just do what you need to do with your employees. So I think the carriers will be a little more flexible on the fully insured side than we would normally have. I'm not super comfortable with that approach myself, and so I wouldn't do that. But I would, talk to your folks, talk to your carrier, talk to your broker and consultant, paper it up, and then get your employees a notice so that they know what you're doing.
One of the things that our practice group got together last week, and we were talking about things, and John, you raised a great point during that meeting. The key to this, as much as anything, is communication to the employees. Mm-hmm. I mean, the folks in the HR department have access to resources, et cetera. More likely not, no matter what your employees are reading or hearing, it's wrong. if they're not getting it from you. So we're encouraging our HR departments to be out there, reach out, make sure they're aware that even if you don't know the answer, find what the questions are so we can address those.
Right.
And so they're not left to trying to get the information on their own.
And certainly there's a legal requirement for ERISA plans to issue a summary material modifications. You don't have to do that for quite some time after the change in the plan. If we have a lot of clients that are not ERISA employers and not subject to ERISA, and so they're not subject to that requirement. But certainly, communication with employees is key and helps things run more smoothly.
You know, John, one thing I was thinking about too that I hadn't really thought about, I probably should have, but the summary of benefits and coverage. To the extent anything we talk about today affects your summary of benefits and coverage or your summary plan description, you may need to issue a new SBC, summary benefits and coverage also. So,
And, you know, we always are somewhat critical, maybe too strong, but you question sometimes why things have to be done, and it seems to be a lot of Big Brother with regard. All of what we're talking about here, the communication with the employees, we might have additional time to do it legally, but practically it may make sense to get that information to your employees as soon as possible so they're aware of what options they have, what applies to them, so they're not left guessing.
yeah, I agree.
One of the things that we continue to read and see a lot about, and this was true before the COVID-19 crisis came up and all the adjustments, and certainly before the 3 stimulus packages, telehealth. Talk a little bit about telehealth, its role in health plans, and maybe what it looks like going forward with regard to our health plans.
Well, I'll just throw in telehealth is certainly a trend right now, but especially during the COVID crisis, a lot of healthcare providers are not wanting to
Face to face.
be face to face with patients. The new wrinkle right now is that under the new CARE Act, if a medical plan provides telehealth benefits without a deductible, it doesn't disqualify that medical plan from being a high deductible health plan that can operate with a health savings account. And so that's that operates for the next 2 years, I believe, Brandon. So
right.
This year and next year, the providing of telehealth benefits with no deductible in a medical plan doesn't disqualify a high deductible health plan. So that's a benefit to employers that have high deductible health plans and their employees right now.
And just to level set, Richard, as a reminder, and I know you know this, but if you have a health savings account with a high deductible plan, up until the CARES Act, which was signed on Friday, you're not allowed to basically have a provision in a plan document, with some exceptions, that allows people to receive treatment without them having to pay money out of pocket that goes towards the deductible. Because if you do, it disqualifies the HSA. And so what basically Congress has done is they've amended the rules to make it easier for people to use telemedicine, and even without cost sharing, and it's not going to jeopardize your structure if you have an HSA with a high deductible plan. For those clients, there are a lot of clients that have high deductible plans. We also have a lot of clients that don't have a high deductible plan. They just have a normal kind of regular, what I would describe as kind of a regular PPO kind of structure. And I don't know that there's a lot of new wrinkles related to, I think you've got a lot of flexibility for most health plans to turn on telehealth if you want. I think providers are turning it on already, whether the employer wants it to be or not. And there's licensing issues related to the physicians providing services through telehealth, but that's really not our employer's job, I don't think, to figure that out. I think that's between the provider and whatever their licensing rules are.
So with that change from the CARES Act, et cetera, will that require amendments to the plan to accommodate the telehealth adjustments, or is that just in practice?
That should probably be amended into the plan also.
And that's an example too.
Right.
That's an example too, where the summary of benefits and coverage might need to be amended, maybe to reflect the fact that it's being covered without cost sharing or with some sort of a different structure than we have in the past.
Well, and again, another example of our encouragement to our clients to get out in front of this, because I think participants would welcome this change. I think a lot of them are hesitant to get face to face. You talk about the physicians and the first responders, and rightfully so, to get in front of those. But I think our participants as well, if they know they had a choice, and from an economic standpoint, either they're not hurt or maybe there's some additional incentive to be able to do that, I think that would be well received. So generally speaking, I know we've talked about a number of different items. What else have you seen in the act, Brandon, that you want to bring to the attention to?
John and I were talking about this right before we started.
Mm-hmm.
And so first there was the Families First Act, which was, I guess, a week ago. I'm losing track. I've been reading this new CARES Act, which was signed on Friday, is 883 pages long. So I've been reading that. But the Families First Act came before that. And really, the big change is that it requires you to provide coverage for coronavirus testing with no cost sharing. And so when you say no, well, what does no cost sharing mean? It means no out-of-pocket expense to the employee, effectively, John, right?
Right.
And so that's the big deal. Is the Families First Act requires testing at no out-of-pocket expense to the employee.
Doesn't count against a deductible. No co-insurance, no copay, anything.
Does not require coverage of treatment.
Mm-hmm.
You can choose to, but it does not require coverage of if you have an employee that has the coronavirus disease. You've got to cover the test at no cost and the related office visit. The office visit related to getting the test, whether that's provided in an urgent care or a doctor's office or telehealth or in the ER. But the treatment itself does not have to be covered unless you want it to. Now, there's a lot of people that believe, and I'm one of these folks, that if you're talking about skating to where the puck is going, that as we get effective treatments available for this, I think employers will be called more to provide coverage for treatment than what they are now. The CARES Act does have a provision related to preventive care, right, John?
The CARES Act has a provision that says that if it's preventative care type items, like certainly vaccine, I think it's contemplating these drugs that may be, that you kind of prophylactic that you take so that you don't get COVID, that those would be covered. But it has to be approved drugs. You can't be going off on something you heard on, saw on some website that's somebody thought is a treatment, or not a treatment, but a prophylactic to getting the COVID.
I was thinking, John, when I read that, that's kind of almost whenever they come up with a drug that will provide preventive, like a vaccine, that's going to have to be covered with no cost sharing.
Yes.
But we don't have that yet.
We don't have it.
So right now, it's just the test that has to be covered at no cost sharing. No coverage for the treatment unless you want to at no cost sharing. And then in terms of the test, it's the related office visit. There's no medical management. You can't, like, for example, say Richard Nix comes into the doctor, and in order for our plan to pay for his coronavirus test and the related office visit, we have to have him have a negative flu test first. You can't do anything like that. So it's literally a no strings attached as it relates to the coronavirus test, but no coverage for treatment. And then like John mentioned, the coverage of the preventive care when it comes out.
I think they're contemplating that maybe they're going to come up with some medications or something that'll prevent you from getting or lessen the symptoms.
Yeah.
And some of them could be over the counter.
Could be.
Sure.
And so, I mean, that's a game changer with regard to what was typically covered under a health plan.
Yeah,
that's right.
But that's, as it relates to health plans, there's not much more in the Families First Act or in the CARES Act that applies to the health plan side of the house. Do you agree, John?
I agree, yeah.
Yeah. So we're left with dealing with the normal rules related to eligibility that we kind of talked about.
Or whatever employers are doing to address these things.
Sure. Yeah.
Well, I mean, I guess one of the things that we keep going back to, there's very few things, but the things that do impact will require amendments in most instances, and we strongly encourage communication out to the participants so that they know what's going on and how it's to be handled. So if we had any ending part, it's get organized, figure out how your plan currently operates, understand, get with your consultant to the extent we can help, we'd be glad to, but you need to figure out how this is going to work and then make the necessary amendments and communications.
And Richard, I would say the one thing that I worry about, and I bet John is right there with me, with related to clients, is they say, okay, we want to do something different than what our plan document says. Can we do that? And the answer is probably yes. But back to your point about amending, why do we care? And this is the number one thing that we care about. Because if you don't get if you're self-funded and you don't get the stop loss carrier's blessing, and then Richard Nix is he's on a ventilator for 6 months as a result, or he has some other, condition that's triggered because of the coronavirus disease, and we've let him out, or we've let him be covered under the plan against the plan terms, the stop loss carrier could use that as a reason to deny coverage, and you as the employer could be stuck with the bill. And same thing, especially on the fully insured side, right, John? Because the fully insured carrier, if you've got an employee that shouldn't have been covered and we've let them stay on the plan and we've not got their blessing and we've not papered it up, then we create exposure.
An example of that is some employers are contemplating allowing their employees to continue under the plan after they terminate employment, which no plan currently allows that. So if an employer wanted to do that, they'd have to be really careful. They'd have to amend their plan if it's self-insured. They'd have to check it with the stop loss carrier. If it's fully insured, they need to see if that could even work with the insurance company. Then there's all sorts of complications. Do you treat this as an alternative to COBRA so that it offsets the COBRA? So that
from cost and timing,
from timing, especially because if the employer is going to provide 18 months of continued coverage after termination of employment, usually they would want that to offset any COBRA period, so that there's not a COBRA period that starts after that. So that's a consideration. And then employers, in the past, when I've seen employers do this, sometimes they want to do it for some groups, some employees, but not others. So that raises non-discrimination issues that you have to be careful. You can't just do that for your headquarters folks and not the people out in the plant. And then finally, there's how would you even do that if an employer says we're going to give you 18 months of coverage after you terminate? What happens if the former employee finds coverage somewhere else during that time period? You don't want to cover them after they have coverage somewhere else. There's some administrative issues to that. And then finally, if you're trying to, a lot of times employers want to equalize employees that may have other coverage that they can get. And so they want to give them some sort of cash equivalent or something instead of the medical coverage if they don't elect the medical coverage. Well, that has tax considerations, and that can really that's really something that has to be considered. So getting back to your point, yes, all this stuff needs to be documented in the amendments, needs to be cleared with the stop loss carriers, the fully insured plans, with the TPAs. It has to be coordinated. There's a lot of coordination that needs to be done to do these things that employers are contemplating to address the new issues here.
Are there any issues, guys, with regard to an employee terminates, goes on COBRA or not, and then in 90 days is rehired? Eligibility coming back in, waiting periods, anything along those lines?
I think it would just affect their premium. In that scenario. So let's say they terminate employment and they get a COBRA notice and they elect COBRA, and then they're rehired and they come back on, I think they would go back to the active employee rate on. And so I think
no waiting periods or anything along those lines.
No, right. They would step back into if they're gone for a short period of time, they would just step back into their cafeteria plan elections.
Right. Other issues you want to?
HIPAA. We talked about this. I think Jim Prince, our partner, talked in the employment video that we produced, I think, a little bit about HIPAA. But just as a reminder, and this is a question for John, this is a softball for John, but Brandon's an employee. I go to Richard Nix, the managing partner of the firm, or former managing partner of the firm. I go to Richard and say, hey, Richard, I'm sick, or I can't come to work, or I can't even work remotely. And Richard shares that with HR. Is that a HIPAA problem? And when do employers running health plans need to worry about HIPAA, and when do they not?
The short answer is no, that's not a HIPAA problem. The HIPAA law, which is the law that provides that health plans and healthcare providers have to secure protected health information of their employees or their patients. And so that law applies to group medical plans. And it basically, one of the basic principles is that the employer cannot take information from the group health plan and use it for employment purposes. So in your example, your example that you just stated, the employees communicating to maybe a supervisor or whoever at work, hey, I've got this problem. That is just communications in the course of their employment relationship.
It's just an HR communication.
It's just an HR communication. Now, if the supervisor went to the benefits office of the company and said, "Hey, this Joe Blow he's been gone for 2 weeks. What is his status?" And the person in the benefits department looks up what's going on, any medical claims that are made by Joe Blow. That's a HIPAA issue. But just these communications in the course of employment, normal course of employment, that's not a HIPAA violation.
We've been getting tons of those questions.
I bet.
Mention it. Yeah.
I bet.
Yeah. Thank you, John.
Typically, you keep close to the vest any
would wanna
type
be
of
careful
medical.
anyway, yes.
But if someone is diagnosed with COVID-19, you want that information because you've got to track and do all the other things. So we're in a tough area right here.
I always use the example of, this is maybe a bad example, but let's pretend that Brandon has been out on leave with the coronavirus disease. And Richard Nix is a benefit plan manager for McAfee and Taft in this example. And Richard Nix learns from the medical plan information that Brandon is out of the hospital and he's healed. And Richard's not trying to share Brandon's confidential information, but he's excited and wants to tell John because he knows John and Brandon are friends. So he goes to John and says, "Hey, guess what? Brandon he's healed of the coronavirus." That is a HIPAA violation because then you've taken information from the health plan, not for any evil reason, but you've shared it in a way that you're not allowed to under HIPAA. And so just the distinction between the HR function and the information received by or transmitted from a health plan, that is the distinction as it relates to HIPAA.
Great. Well, we've obviously been inundated with questions. When something like this happens, different areas play a more important role. Obviously, employee benefits and health plans are extremely important. They're always important, but ever more so when it comes to a crisis of this type. I know, Brandon, it's contemplated the practice group is maybe going to have some conference calls for clients. Do you want to talk a little bit about that, or just give them a heads up?
We've kicked around the idea, and I think we're likely to do it, of having kind of a weekly town hall of telephone call, which is basically people can call in at a certain time each week. We'll be sending out more information, but people can call in, and then not that everybody can get on and ask questions, but they can email questions, and then we'll maybe answer some of those questions in this week. But and also maybe tell employers, our clients, what we've learned since we had our last town hall discussion. But that's kind of the idea, Richard, is that we'll just some sort of a weekly call where we will update people on what's going on and answer any questions that they have, and they email over. So that's the idea. More information to come on that.
Well, and that's a good segue as we led into the discussion today. We have the COVID-19 Resource Center. We're going to continue to put the links to these type of webinars, all the alerts that we do. We're trying to get this information out as fast as we learn it. I think the conference calls that this practice group is going to do for and on behalf of the clients and friends that we have, so that we can try and address the specific questions that they may have, will be helpful. But I would encourage you to access the Resource Center early and often with regard to that, and we're continuing to update that. And likewise, we will continue to be committed to being on the front end and the cutting edge with regard to any changes that comes about, either by the act or as regulations and other implementation items come forth. We will commit to getting that to you, so that our objective is for us to be your eyes and ears, and at the end of the day, you can make informed and timely decisions. So with that, thank you for joining us today. Stay safe. Thank you.